Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.
Hello and welcome to the program. This is Tice Madox Solicitors, your preferred firm, and I am Justice Maduforo. I'm a solicitor of the Supreme Court of England and Wales. I'm also the barrister and solicitor of the Supreme Court of Nigeria. This program, as you all know, kickstarts your consciousness to law. This is not a legal advice program. It merely a driver to wake up your consciousness so that you could do the right thing. That is what this program is all about. It is not a legal advice, and therefore anything I say on this program or any of my discussions on this program, they are not legal advice, and therefore you must not act on them. The purpose of it is for you to go to the right place. The information is on the screen where you could get the right advice tailor-made for your circumstance, and where you can apply it the right way and achieve the right result. So on that note, ladies and gentlemen, my discussion today is immigration. And my topic will be sole responsibility, serious and compelling circumstances. Sole responsibility, serious and compelling circumstances. Now, before I dive into that, and you all know that Tice Madox Solicitors does not only represent you in immigration. We are the experts in serious criminal matters, serious criminal cases. And also we are experts in civil litigations, in county court, in the High Court of Justice. And obviously we are the expert in family matters, in any family matter you're going through. Of course, that you must have watched it through the intro. So you know the right place to go. You know the right place to go. You know the right number to dial. In that circumstance of yours, we are expert in contracts, in employment matter, from employment tribunal to the employment appeal tribunal, and all the way up, depending on this type of case and whether it's subject to an appeal or for permission to appeal. Ladies and gentlemen, you have all it takes into one. A firm that will prepare you, and a firm that will litigate for you, a firm that will advocate for you. So you have it all in one. And as an experienced advocate myself, you are sure to receive the best representation and the best advocacy in these courts of records that I've mentioned, and in all courts of jurisdictions that I've just mentioned to you. So that is bringing your attention to what Tice Madox Solicitors can offer you. Once you have need for us, of course you have need for us. Of course you do, because the United Kingdom is a country of laws. And everything that we do here is subject to the law, and therefore you are not exception. No one is exception, irrespective of your class, irrespective of your color, irrespective of your race, irrespective of your nationality, irrespective of whoever you are, irrespective of your immigration status in this country, you are subject to the law. And the law is so crucial and blind that it gives no preference to you, but you must apply it the way it works, that you can achieve the result. That is what Tice Madox is. Tice Madox Solicitors focuses and presents itself as a driver, as a tool to achieve your goal in this country. It's a country of laws. It's a country of laws, and it's a country of laws. And therefore, if you align properly with the right information, you get the right achievement that you need. You get the right success that you need. We will be your preferred firm to drive you to your focus. My topic today is sole responsibility under immigration law, serious and compelling circumstance. Now, what do I mean by that? Now, I said this program, and I chose this topic because of several circumstances that is evolving. Now, families are being torn apart as a result of the father or the mother migrating years back or recently to the United Kingdom, and their words, their children, their guardians, their adopted child are over the country where they migrated from, and things have shaped up well for you. Thank God for that. Now, the question now is that you get to the point that you want to reunite with your children. What do? Some of you have obtained limited leave to remain, either through children you already have here, from another woman, another man, but you have that concern for the other children you have in your country. Or some of you have obtained your leave through any other means, but you're concerned about your children you left in another country. Now, this discussion is exclusive of asylum cases, because if your leave to remain was obtained through asylum, the process to bring in your children is a different kettle of fish. So it is not the parameter of my discussion today. So if you're in that tune, of course, you know from the beginning when you made this application, when you made the asylum application, what needed to be done. But in this circumstance here, my purview of my discussion is centered solely in immigration law, in the sense that those of you who have come over and you have now settled, some of you are not settled yet, but some of you have limited leave to remain. But you are desirous, you are anxious, you are very interested. You cannot wait to reunite your children with you, or your child, or your guardian, or your stepchild or stepdaughter, or your adopted child. These are all your children. Now, you want to bring them back. You know that at the moment, there's been a lot of issues and flux about how children will join their parents here. What the law is doing to assist that movement and that cooperation. What the law is doing to unite families, to help family life. Now, the country, United Kingdom particularly, will always say they want family life to exist. But in reality, the laws, the rules that guide this to happen, it is not in practice, because it's in theory. But because the threshold of which to unite this family has been kept so high that some of you cannot meet it. The threshold of which you bring your children on the straightforward of it, you cannot achieve it. So the purpose of my discussion is to bring in and narrow down those narrow ways where you can achieve this purpose and success that you desire. That is why you come to the right firm that can give you the right information. You cannot do that anywhere. Tice Madox Solicitors and myself, we will tailor down your circumstances. That's very important. And then advise you the way it could work for your application to succeed. For your application to succeed, for the appeal to succeed, depending on which stage that you are, whether you're considering or contemplating to bring your children over, or whether you've already done that, refusal is a letter you received, or that you're already in first year tribunal appealing that process through the law, or you're in the court of appeal, or you're in upper tribunal appealing further from the first year tribunal's decision against you. Whichever stage that you are, you need to do one thing and do yourself a favor, is to pass over there and ponder whether you have done the right thing going forward. What did the Home Office say about your application that you're appealing? What is the thing that you're countering Home Office on in terms of the reason for refusal? What are you presenting to court? Let me tell you something. The way the Home Office refuses the application and the grounds of which they refuse the application may not be the grounds of which the court, the first year tribunal or the upper tribunal may agree on. The upper tribunal may actually say that this is not the right way, the Home Office has got it wrong. And even at that, you, the applicant, you also got it wrong. And therefore, your appeal will be refused. So you need to go back to the firm that understand how to tailor these things together. And it's only Tice Madox Solicitors that can do that for you. We will tailor down every single point, every single circumstance that you're going through, and to make sure that it aligns with the law, with the facts, and with circumstance. So therefore, what am I saying here? You want to bring your words over, but there's a deficiency in doing that. One of the deficiencies in doing that is, for instance, some of you have financial limitations, which the law provides under paragraph 276 of the immigration rules. We provide for your children to come join you here, and that's a sole responsibility under the sole responsibility rules, or that you are sole responsible for this child. Either your father, the husband, or the wife, or yourself, or one parent, or both parents are responsible for this child. Now, there are rules. Some of you are married. Some of you unmarried have issues with your spouse here. But because of that, you've now decided to take care of the child yourself. Your spouse is giving up of that. They're here, there's no contact. And as a matter of fact, this is all going. It's a lot of dispute and conflict between marriages these days in the United Kingdom. So partners are going their separate ways, even when they have children. Now, this particular issue here is for those who have children that have been here. One of them here, or both are here, but the child is overseas. Question is, how do you bring them over? Now, the man is here, you're the one paying or taking care of this child. The woman has forgotten about the child, not interested, not involved. The man is not involved, or you are involved. The man is not involved, or the man is involved, or you are involved, vice versa. The question now is that, are you meeting the rules to bring the child over here? So you need to think twice. Some of you have this mindset, I'm the one paying for this child. I'm the one doing everything for this child. I'm the one doing all that. I'm the one. But you need to narrow down what the law says in terms of bringing the child over. This area is a very technical area. And some of you have failed. As a matter of fact, not even failed. Some of you, when you look and read and understand and you're informed about the task ahead of you or the requirements to bring this child over, some of you just give up. You don't need to give up. This is your family. You don't need to give up. As a matter of fact, what would your child tell you when he grows up? That you gave up on him or her to give him that opportunity that he deserved to come and join you so that you can keep an eye on your child. Remember that your cardinal principle as a parent is your obligation is not a choice. It's an obligation to look after the child. And so if you fail to do that, you failed in life. I'm sorry to say that, but that is the position. Because that's what family life is. You have responsibility of the child, and that's what the law says. You have responsibility of the child until the child gets to 18 years of age. Then at that point in time, your responsibility and your obligation of this child ceases. It becomes an adult, depending on the country where you are coming from. Some countries have moved their adulthood to 20 years, some to 21. But as long as you're in this country, the country sees your child as below 18 years of age as still under your care. So if you have failed to do that, you may be thinking that you're failing in life in terms of your responsibility to the child, not to your private life, but to the child. So as a matter of fact, you want to do this to bring the child over. So a lot of you have come to the firm and have discussed this, and we have also notified you on the steps that you need to take. Now, first thing first to do that is to get the right information. That's a very important thing because this area is a very technical area. It's not a straightforward area. The 276 immigration rules make it look as if it's get this, get that. No, some of you know that when it comes to finances, you may be found wanting. You are not meeting up to the task. You're getting something but not sufficient. Then that is a flaw already, but that does not cancel you out. Second part is issue about accommodation. That is also a fault. Some of you may have a one-bedroom you live in, or two-bed house, or one-bed house, self-contained that you're living in, or shared accommodation, or multiple occupancy that you're living in. You may think that has taken you out from the purview of the law. It hasn't. Under the law, in terms of the immigration rules, that has taken you out. But you can come in. You see, this is where it's becoming very interesting. And that's why you get the information from the right people that can give you the information you need, even when you're not ready now. You will give a time frame when you need to be ready to do that before the law changes. So that's the exactly important factor of my discussion here. So as a result of that, you moved away from there. Some of you also look at the fact of your immigration status. Some of you are British citizens. Some of you have indefinite leave to remain. Of course, in terms of immigration status, you qualify in that aspect. But some of you also have limited leave to remain. And you're going to be on limited leave to remain for a number of either 5 years' time or 10 years' time. The question is that, do you want to wait until you get a 10 years and apply for indefinite leave to remain, or 5 years to apply for indefinite leave to remain before you to apply for your child or your stepchild or your adopted child to come over? You cannot wait for that. That's why you need solicitors like us who understand the technical aspect of this application, the technical aspect of it, the legal somersault that's required to take place for these applications to walk through. Even in your limited leave to remain status, is possible, absolutely possible. And that is why my topic today is what is called sole responsibility, and then we talk about serious and compelling circumstances. Now, this is where some of you don't understand how it works. Now, let me go further to say this. Now, a very good practice or a very sound solicitor like me understands the purpose and importance of preparation. Preparation is the key. And that is where you dwell quite a lot. So if you are with a firm who is acting for you or who is processing your appeal, who is presenting you in your criminal matters, in the magistrate court, in the crown court, in the court of appeal, and in the family matters, and they're not preparing you, or you're in employment tribunal, or you're in any professional tribunal hearing, and that solicitor that you have instructed are not preparing you sufficiently, then something is lacking, because that food will not be sweet in metaphorical way. What do I mean by that? Preparation is the key. Preparation is the key. Some of you walk down the roads in the United Kingdom, you see construction taking place. What do I mean by that? I want to use this analogy to bring you back in to say that this is the way it works. Some of you live in the neighborhood, so think now, you live in a neighborhood, and that neighborhood has got some barricades and construction companies coming in, and they have acquired the land and they have fenced the land with some fences or some wood coverage, and they have put a mark on it that this construction is going on, and they have put forward it's going to be 1 bedroom, 2 bedroom flats and on offer. And so it's an under offer or is an ongoing offer, and inviting you to come to bid, inviting you to come have a look at this oncoming building. They want you to participate. They want you to buy. Now, you ask yourself, what am I going to buy there? There is only empty lands. Now, the issue is not that. The issue is that for that proposal to come in, for that invitation to go out, this construction company has done what is called preparation first, and they know that they're taking off soundly and they will deliver. So that is what's called preparation. That applies to every professional representation, be it in the construction world, be it in the oil and gas sector, be it in the legal sector, be it in the medical field. And the same thing applies when you see your GP. Before then, the GP will consult with you, examine you, and do all that. Ask you to take the samples or test or run X-rays or MR scan. They do all that. These are preparation to understand, so that when they are now going further to operate or to refer you to a specialist, they are comfortable that the result has come in to show that this is what needs to be done. So either you're referred or you're taken to the emergency theater, emergency operation, or you're referred to any other specialist. That means now that they have done preparation. So preparation in legal representation are very crucial, especially in immigration applications. So if you are with the firm, you know preparation has not been done. Why? How do you know? They've not listed out certain things, that is the ingredients that's required, and they've not guided you through these ingredients and how it will work out for you. If they just ask you, get this, look out, get this, get it. No, then you know that you are not just being carried along, because that is not sufficient representation. That's not sufficient preparation. Preparation is very key, especially narrowing down in the context of my discussion, so responsibility, because it's very crucial. This child is outside, and before he needs to be absolutely sure, because at that point in time, the power to bring in or to stay back is in the hands of the Home Office. So it's in the hands of the Home Office. So how do you persuade them? It's not in a situation whereby you're already here and the child and you are here with the child. That is different circumstance because both of you are here. So even the Home Office, even they don't want to grant you, they're thinking how to remove the child or remove you. That's another tax for them. But in this instance, they have the sole authority to keep you your child outside the country when they refuse your application. But you don't want that. What do I mean? That is why you need to prepare, and once the application is lodged, the hands of the Home Office, the caseworker who is going to make decisions in your entry clearance application for your child to join you either on limited leave to remain, going to indefinite leave, or for only indefinite leave to remain, or straight to indefinite leave, or straight to limited leave to remain. If you want to be sure that this caseworker will do the right thing and you will receive a decision, then preparation is your friend. And if you don't want to cut with this preparation, then you are not ready yet, and you already know the result of that application that you're about to lodge. Compelling and serious circumstances, that is, the law provides is undesirable, that it will be undesirable to keep this child away. Serious and compelling circumstances, and that it is undesirable to keep this child away. What is that? This is a very omnibus phrase and sentence that only those who have the experience, have the tenacity, have the ability, have the technical skill, have the technical know-how, who knows the experience, the practical, the theory that goes with it, and have done it and have achieved result, can understand and unravel what serious and compelling circumstances that it be undesirable to remove a child or to exclude the child out of the United Kingdom. You need Tice Madox solicitors that understand this terminology and understand the preparation and the ingredient it requires to fit in and to convince the Home Office that this matter is serious and the child, it will not be reasonable, or it will be unreasonable and undesirable to exclude this child. These are the point of this discussion and the context I am discussing today. I said this with all certainty and with the knowledge and the technical certainty and legal certainty, and in respect to whether or not this is a doable way, a doable aspect to bring your child into the United Kingdom. Now, some of you may think in your mind, oh, my child is under 18. Now, one of the deficiencies and one of the problems most of you have gone through, not by your making, is as a result of while you are waiting for your indefinite leave to remain, and your child has now crossed 18 years of age. What do? You don't understand the law. So you need to come to the right people to unravel it. Let me tell you, we have succeeded to bring in children who are 20 years of age, 21 years of age, 22 years of age, 25 years of age, 30 years of age. Trust me. We have done that, and you ask yourself, how do you do that? This child is above 18. The law says 18 years. Must be under 18. So we have succeeded in doing that, ladies and gentlemen. We have succeeded in bringing that. That is why we plug in the serious and compelling circumstances. If you do not know how to argue this phrase, then you don't need to start. You just pause. All the details that you need to achieve this success is on the screen. That's why you come to Tice Madox Solicitors. We will do the rest for you. We will sit down and do the preparation, preparing you for this application. Never mind if your child is above 18 years of age, 20, 21, 30, 35, and you have your indefinite leave to remain. And also, do not wait until you get your indefinite. If you have limited leave to remain, 2.5 years of age, 2.5 years you have, or you've gone for another 2.5, and your child is 16, 17, and going to 18, or your child has even crossed 18 years of age, and you have all that he requires in terms of all the other part, but the child is now above 18, or the child is under 18, but you have limited leave to remain, and you think you're out of the scheme, you cannot bring the child in, pause there. Pause there. Come to the right people. The right information is what you need. Because even if you go to appeal and you got the wrong information, wrong advice, and you go on appeal, the court will not going to give you any separate treatment. There's no concession. The court can only sympathize with you for your bad advice you received or wrong information you received. It will not affect your human right. It will not affect the child coming in. That's the case law. This is Upper Tribunal case law of 2018, the case of Mansu. The court have made it clear. So do not risk getting wrong information. Do not risk it, because it will not affect you. Even if you complain against anyone, it will not change the fact that you have made a wrong application and it has gone. And that time has gone. But that's why you pause. Whoever that needs this information, direct them to Tice Madox Solicitors. Those of them that need this information regarding sole responsibility to bring their child over from any part of the world to join them in the United Kingdom and to reunite your family. Because Tice Madox Solicitors, we are pro-family. We are pro-family. We want families to stay together, because you cannot effectively police and train up a child when you are doing so by Skype or by WhatsApp or by FaceTime. You can do that. Technology has a separate way, but facial and day-to-day interaction and human contact with your child, hugging the child, giving the child warmth, and guiding the child, putting simple socks on the child, and simple guiding him in his own work, that's sufficient enough. You cannot substitute that. Tice Madox Solicitors, we are pro-family. We will guide you to ensure that your word comes to join you, not only in this particular field, in all areas of immigration, in all areas of asylum cases. And then taking that away, you also know that when it comes to serious criminal offenses, you will know that Tice Madox has got your back. We got your back from murder to manslaughter to serious fraud cases. We have it all going on currently. And in the past, we have achieved result on that. We have given them all the best. We have represented them to the best. We have given the best legal expertise they require. So especially the minority here who may have access to this television, who may watch this at the YouTube, or whoever is watching this in any platform that you watch this from, know very well the right information is the right key for you. As long as you live in the United Kingdom here, you need the law. And this country is a country of laws. And you want to make sure that you do not make the mistakes that others have made. Get the right information here on the screen. Contact us. Come down to the office. Come down to the office. Put aside fear. Put aside faithlessness. Put aside doubts. Put aside what you've gone through in the hands of other representatives before. Put it aside. Take a fresh step. Come to the right people that can guide you. You get your result. That's what we are here for. My name is Justice Maduforo. I am a seasoned solicitor, experienced advocate that can guide you step by step. You achieve your result. Till next time again, you know your host, and you know the most favorable and the most firm and the best firm you will always visit. Take this detail, pass it on to other people, even if you don't need it. And I'm sure you need us, because it's a country of law. As long as you live here, you need us. Ladies and gentlemen, thank you for today. Until I come back your way again, I say God bless you. Stay tuned.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.